Hello, welcome to this podcast on licenses, leases and tenancies at will. I'm going to focus in this podcast on commercial premises rather than residential premises. This information shouldn't be taken as a substitute for getting advice from a professional, for example, a practicing solicitor. Okay, well, to start off with then, good starting point is to ask the question, does it matter? Is there an important distinction between these three types of way of holding, and I use this term loosely, holding interests in property? Is it important? Does it matter if the interest that you have in the property is by way of lease, license or tenancy at will? Well, it does, because the types of interests that you have may well make a substantial difference to how secure you are in regards to that property. And when I say secure, I mean the extent to which you can, well, stay in the premises, basically. If, let's say, the ultimate owner of the premises, let's say the freeholder, if that freeholder wants you out, to what extent do you have security in that property? You might sometimes hear it described as security of tenure. So let's say, by way of example, that you as a tenant, let's say you took a 5-year lease, commercial lease, then actually the law says that at the end of that 5-year period, it's not necessarily, note, not necessarily the case that you will be required to leave the premises. It all depends on the circumstances surrounding the situation. So why are you not necessarily, as the tenant, required to leave the premises? Well, it's in consequence of the Landlord and Tenant Act 1954 and various provisions within that Act as updated. Now, I think that comment that I've just made might leave you thinking, if you didn't already know about the Landlord and Tenant Act 1954, that is a hard position from the perspective of the landlord. Why should you, let's say you're the landlord, why should you enter into a lease for 5 years, let's say, with a tenant, expecting at the end of that 5 years for those premises to be clear, and then suddenly, at the end of the 5 years, maybe you want to lease it to somebody else, along comes the provisions of this Act, so to speak, and it gives the possibility, no, just the possibility of, under certain circumstances, the tenant being able to renew its lease. Now, essentially, one of the goals of the Landlord and Tenant Act 54 was to ensure that the economy ran along smoothly. I'll try and illustrate here. If you have let's say, if you have a tenant and they have taken on a 5-year lease, and the business that they're running is doing well, obviously the premises is an integral part of that business. Let's say at the end of that 5 years they were required to move on. There'll be all that associated upheaval that the move would entail, having to find new premises, costs, impact on the employees and so on. And so the Landlord and Tenant Act was to try and mitigate against that, and to give the opportunity in certain specified circumstances for tenants to actually be able to take on a similar lease for a similar period of time, so to carry on. Now, that right to carry on, it's not an absolute right, and in fact it can be specifically removed as a right if the correct procedures are followed by the landlord with the agreement of the tenant. I'll deal with that in another podcast, one that deals specifically with Landlord and Tenant Act 54, but for the moment I'm just using this as an illustration as to why it's important to know whether or not your interest is that of a tenant, licensee or tenant at will. And the answer as to why it's important to know whether or not you're in there as a tenant, licensee or tenant at will, and this is just one example, is that under the Landlord and Tenant Act 54, you're not protected if you're a licensee or a tenant at will. It's only possible for you to be protected if you're a tenant. So there's just one example as to why it's important to know whether you're actually in there in the premises under license to occupy as a tenant at will, or under a lease. proper lease, if I can call it that. So, what are the essential components of a lease, whether it's a commercial lease or a residential lease? Well, firstly, there has to be exclusive possession, and that has to be for a period of time that's capable of ascertainment, capable of being ascertained. And I've put down there the rent, but actually cases have established that it doesn't actually necessarily have to be a rent. Okay, let's go on to the next slide then. Now, this case, Mr. Street and Mrs. Mountford. Now, I've previously said that I'm going to focus on commercial leases, so you might think it's a bit odd that I'm going to leap into this residential case. It did involve residential property, but the reason that I'm doing that is because it's a sort of mainstay case, the one that sort of established what the components were of leases, and so yeah, good starting point. So, what were the facts in this particular case? Well, there were two parties involved. There was Mr. Street, who owned the freehold of some furnished rooms in a place called Boscombe, and the other party was Mrs. Mountford. And she was given the right to occupy these furnished rooms. It was done under a written agreement. It stated that Mrs. Mountford had the right to occupy the room at a licence fee. It stated at a licence fee of, well, £37 a week. And it also contained a provision that the circumstances do not and are not intended to give a tenancy protected under the Rent Acts. Now, Mrs. Mountford had exclusive possession of the room, and a few months after she moved in, she actually initiated a fair rent procedure under the Rent Acts, at which point Mr. Street went to court and he sought a judgment that there was no tenancy, and that Mrs. Mountford was just there as a licensee. She was only holding under a licence. She's not a tenant and couldn't have the protection of the Rent Acts. I'll say more about licence particulars, but anyway, sufficient to note that a licensee wasn't allowed the protection of the Rent Acts. Now, the county court judge held that Mrs. Mountford was a tenant and was entitled to the protection of the Rent Acts, but Mr. Street then appealed to the Court of Appeal, and the Court of Appeal held that Mrs. Mountford was actually a licensee, so they overturned the county court judgment, and Mrs. Mountford then appealed to the House of Lords, as it then was. This is still the House of Lords, obviously, but in the sense that at the time that was the highest court, rather than as it is now the Supreme Court. So anyway, the House of Lords, as it then was in terms of law courts, said that the test as to whether occupancy of residential accommodation was a tenancy or licence was as follows. On the true construction of the agreement, the occupier had been granted exclusive possession of the accommodation for a fixed or periodic term under a stated rent. Now, accordingly, since the effect of the agreement between Mrs. Mountford and Mr. Street was to grant Mrs. Mountford exclusive possession for a fixed term under a stated rent, and there were no circumstances that existed to sort of negative that presumption of a tenancy, they said Mrs. Mountford is a tenant. Now, the same sort of principles apply to commercial situations too, and it's interesting to note that simply labelling an agreement as a licence doesn't necessarily actually make it a licence. Anyway, I'm going to stop there, and this is the end of part 1, and start up again with part 2, looking at other bits and pieces to do with licences, tenancies at will and leases. Thanks for listening. Cheers.